In this discussion, I want to talk about two programs that can help immigrants who have been abused by their spouses or significant others. The Violence Against Women's Act program and the U Visa program. In each situation, we're talking about individuals who have been abused emotionally, abused physically, abused financially. We're talking about individuals who have been afraid to seek assistance for fear of being deported. Many of the points in today's discussion will center on female immigrants, but they apply equally to immigrant males and immigrant children. So let's get started. There are 5 key differences between the two programs, which means in some cases, an applicant, an immigrant, can qualify for one of these programs, say the Violence Against Women's Act program, but not the other, the U Visa program, or vice versa. They may qualify for the U Visa, but not VAWA, the Violence Against Women's Act program. So let's go through these 5 key criteria that will determine whether or not a person can seek one or the other. And in fact, in many cases, individuals can seek relief under both programs. So they're not exclusive. But sometimes one is better for an individual than another. Let's get into it. The 5 criteria that we're going to discuss today are: 1, the visa limits on each program. Secondly, which programs, if any, require qualifying relatives. 3, what's the interaction with law enforcement authorities? 4th, what's the good moral character requirement necessary to qualify for relief under these programs? And 5th, what degree of harm, what type of harm must have been perpetuated upon the immigrant in order for them to qualify for benefits under one or the other program? Let's begin with visa limits. Visa limits pertains to the amount of grants of visas that will be given to immigrants in a given year. The U Visa program has limits, whereas VAWA doesn't. U Visa program has 10,000 visas per year as its cap. That means once the government has awarded 10,000 U visas, that's it for the year. The rest of the cases are rolled over. Now, in reality, the U Visa program moves very slow because of that factor. The U Visa program at present is well over 200,000 cases behind. They're backlogged. But recently, the government passed a series or implemented a series of new procedures that will allow applicants for U visas to qualify for a temporary work permit and also receive a temporary grant of deferred prosecution, which means the government won't try to deport them. Now, in both programs, they have that set up. But in VAWA, that comes much sooner in the process. It's always come much sooner. And under VAWA, you can move to the second stage much sooner. So the U Visa program moves slower. But in some cases, the U Visa program may be the only option for an immigrant. So they have to go the long way around. But given the change in policy with the fact that now work permits and deferred prosecution will be given to immigrants in 4-year increments, as long as they renew it every 4 years, they'll be okay until they get to the final point. At the final point, they receive a U visa. 3 years later, they can apply to become a permanent residence holder. Under VAWA, the Violence Against Women's Act, they do a prima facie determination, which is an initial review. Then later they move to the application for permanent residency, much sooner. But in both programs, if handled correctly, and if an applicant meets all requirements, will allow a person to obtain permanent residency as a self-petitioner. That means without the help of their spouse or significant other or any other person. And that's the importance of both of these programs. They both protect an individual, from being deported, but both allow them to work temporarily while their paperwork is being processed. That's what makes them both very important. The second requirement is qualifying relatives. Under VAWA, the requirement is that the victim has to have been related to the person as husband, wife, as spouse. And the spouse must have been either a U.S. citizen or a lawful permanent resident at the time the victimizing, the crime was taking place, the harm was taking place. Now, note that under VAWA, you do not need a criminal conviction of the perpetuator, the person perpetuating the harm upon the immigrant. There doesn't have to be an official crime, but there has to be very substantial, extreme harm to the immigrant, mental harm, physical harm, financial harm, and all of it adds up. And that's what allows an individual to go forward under a Violence Against Women's Act petition. And if successful, as I said, they win a green card. Under the U visa, there's no such requirement that an individual has to have a marriage relationship with the person. So let's take the situation of a female that's lived with a U.S. citizen or a permanent resident for 6 or 7 years. Maybe they had a couple of children together, and that person has consistently abused them, has not allowed them to use the phone, has not allowed them to have friends, has not allowed them to work, doesn't allow them to go to church, and controls all their behavior. Under the Violence Against Women's Act, that set of facts would be very strong to winning under a VAWA petition. Under the U visa, because they were never married, they can still go forward. Under VAWA, no, because they weren't married. So in that case, the individual seeking benefits, the immigrant who has been abused, would want to file under the U visa program. Let's move on to the third criteria, that of helpfulness to law enforcement agencies. Under VAWA, cooperation with the local law enforcement or federal law enforcement agencies, the police department, the sheriff's department, is not needed to qualify for VAWA. Under the U visa, it is necessary. And in fact, the law enforcement agency officer must sign on to a certification that the immigrant has been helpful to them. So let's take the situation where an immigrant spouse or live-in companion has been abused physically, mentally, financially, and during the course of that relationship, that person has had a knife thrown at him, has been hit over the head with a telephone, has been slugged with punches, has been forced to have relationships with the other person when they don't want to, when it's not consensual. If the immigrant has never reported that to law enforcement, has never sought help at a local shelter or at a nonprofit organization, then there's no evidence. There will be no crime. And so under the U visa, that type of behavior that's not reported will not qualify the person to receive the certification to win benefits under the U visa. Under VAWA, yes, the person could still proceed. And in fact, circumstances like that would make a VAWA case very strong because the extreme abuse, the extreme cruelty is pretty obvious. Of course, there will still be a proof problem, but the circumstances are clear as to whether or not there was extreme abuse and cruelty. Again, under the U visa, though, the person wouldn't be able to go forward because they haven't been able to document that there was a crime. Now, what that means, of course, is that the U visa has consequences far outside VAWA, which I will discuss in a subsequent video. But what it means is that an individual could be involved in a relationship and something happens outside the home, but it does have an effect on the immigrant. And they would still be able to perhaps qualify for a U visa. So that's another important difference that will determine in some cases whether an abused immigrant can seek benefits under VAWA or under the U visa. A fourth criteria is that of good moral character. Under the Violence Against Women Act, the immigrant must demonstrate good moral character. So they're going to have to get police records from everywhere they lived. And that is going to be really critical. In some cases where if they've committed a crime, if it's something that has to do with the person that's perpetuated the harm on them, then that may excuse the convictions, or if the convictions have been minor. Under the U visa, they're going to be cleared of that because there's not that strong of a good moral character requirement. However, under the U visa, that issue is going to come full force at the end when they do seek permanent residency benefits. Then they're going to have to readdress those issues. But assuming that the U visa process is taking its normal course, then a person's going to be relatively safe because they've more than rehabilitated themselves. They've more than worked with law enforcement. And so they should, in most cases, be able to work around the good moral character requirement at the permanent residency stage. And along that line, you have to be aware that not all crimes are equal. Some crimes will be stronger than others, but again, the cooperation is going to be very, very crucial. So this is one of those issues, good moral character, where even if there's a slight inkling, immigrants should always consult with someone if they have even the slightest problem in their case. These issues can really destroy an otherwise great petition, even a great self-petition, if they're not handled correctly. The fifth is the proof of harm and the period of that harm, really. Under the Violence Against Women Act, an individual has to file for benefits if they're applying with the agency, USCIS, within 2 years of being divorced. So in a situation where the woman has been married and they've gotten divorced, but a divorce occurred 3 years ago, then affirmatively she wouldn't be able to apply with the agency. Of course, if she got thrown into immigration court, then she would still be able to apply in most situations. Now, under VAWA, there isn't that 2-year cutoff requirement. So then the last factor in there is the degree of harm. What is the degree of harm? Under the Violence Against Women Act, as I have said earlier, it's a matter of you have to show extreme cruelty, extreme harm. And that cruelty doesn't need to be, that harm doesn't necessarily need to be just physical. It doesn't need to be a battery. It doesn't need to be a punch. But the combination, the situation that a woman is totally controlled, that can't have any friends, that can't call her family without the other person approving it, that has no access to the bank account, that isn't allowed a checkbook, can only go grocery shopping when the other person is there. Those situations are going to be strong enough in many, many, many cases to win green card benefits under the Violence Against Women Act program. Under the U visa, an applicant has to show substantial physical or mental abuse, suffering as a result of the criminal activity. So if what they've suffered is unrelated, if the harm is unrelated to the criminal activity that they're helping the government on, they're not going to be certified for a U visa. They're not going to qualify. And this is the biggest problem I see with U visas. Oftentimes I have individuals come to my office and they've been told by a friend, a notario, maybe even another lawyer, that they should seek a U visa. But their harm isn't connected to the crime, or there isn't substantial, then their ability to win a U visa is going to be slim at best. And in many cases, it's not going to work. And so they're just putting themselves on the radar that, hey, I'm here without papers and I don't have a strong case. What's going to happen afterwards? The government will know about them and may even on the previous administration, it certainly happened, and place them in proceedings, which is not what you want to happen. So if you're thinking about filing a U visa case or thinking about filing a VAWA case, be careful, because there are strict requirements in both of them that you must meet. And you do need to have them professionally evaluated and assessed before you file the self-petition. And remember, the beauty about the self-petition is you don't have to go and get your spouse or significant other or anyone to help you fill it out. You don't need a sponsor. You're your own sponsor. And that's really, really critical in these situations. So I hope this discussion has helped you see two programs that can really help you if you've been suffering abuse at the hands of a spouse, a former spouse, or significant other. I really, really wish you the best, but you really need to take to heart the strictness of the requirements. Don't assume because on the surface you have a case that they're going to be tight enough, strong enough, forceful enough for you to succeed. But instead of just giving up, make sure you consult with someone to really help guide you through the process. Because the end result is this: you become a permanent resident. And that's what you want, at least until you qualify to become a citizen. Take care. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VataraImmigrationLaw.com. My name is Carlos Vatara. I appreciate your time and hopefully we'll be talking again very, very soon.